And Court TV's next trial that we're expecting to begin, we were expecting to begin this morning. This is a live trial, this is not a live look, but this is a look inside Milwaukee. And this is the defendant. His name is Theodore Edgecomb. He's accused of killing Milwaukee attorney Jason Cleereman in September of 2020. We thought that today was going to be the beginning of this trial. We were expecting there to be a motion hearing next hour, and then it was going to be jury selection, and then opening statements tomorrow. But we've just been informed from our team in Milwaukee that there has been a delay. It's been continued on some level. We're not quite sure. We're hearing that it could be an issue with the judge, possibly a medical issue. We will get you all the information as soon as we get it. But let's start by looking at the case itself. And here, for that, is Court TV legal correspondent Chanley Painter.
We hope everyone continues to, keep a open mind and not try the case in the media and just wait till the facts come about.
The case involves Theodore Edgecomb, accused of murder in the shooting death of immigration attorney Jason Cleereman. Police claim it started out as a verbal altercation while Edgecomb was riding his bicycle in Milwaukee last year, and it ended with Edgecomb shooting and killing Cleereman. Prosecutors say Edgecomb provoked the attack.
This was a senseless act. There was no reason for it.
But defense attorneys say Edgecomb was the victim and pointed to this surveillance video showing Cleereman following Edgecomb, then getting out of his car and approaching the cyclist moments before Edgecomb fires.
This is a clear case of self-defense, and we look forward to and maintain confidence in our judicial system to establish the same.
The case has drawn comparisons to Kyle Rittenhouse, who claimed at his trial he was defending himself when he shot and killed 2 men and injured a third during protest in the neighboring city of Kenosha last year.
He lunges at me with his pistol pointed directly at my head.
The defense team plans to call John Black, the same expert whose testimony helped acquit Rittenhouse.
I have a known distance, and I have a time that it took him to run that known distance.
Theodore Edgecomb deserves the same right that Kyle Rittenhouse got.
But Cleereman's widow, a witness to the shooting, says Edgecomb was the only one armed and violent that night.
My husband got out because he had to just talk to the man, and the guy waited, and I'm just standing there waiting. And as my husband got real close, I saw him pull out a gun. And my husband never saw it because he was close and shot him point blank in the head. And I saw my husband drop to the ground.
At the time of the shooting, Edgecomb was out on bond, and as a condition of his release, he was not allowed to have a gun. He was arrested about 6 months later in Kentucky. The defense is fighting to limit what the jury should hear about his other case and argues it shouldn't have any bearing on Edgecomb's right to defend himself.
The state's attempt here is to bootstrap this bail jumping charge to prejudice the jury by confusing them to try to continue a narrative that somehow Mr. Edgecomb would not be privileged to exercise self-defense because he would perhaps have an order that would deny him the right to have a firearm in the first place.
Edgecomb is facing 1 count of first-degree reckless homicide and 2 counts of bail jumping. He is being held on a $250,000 cash bond.
All right, thanks to Chanley Painter. Joining us now, trial attorney C.K. Hoffler. She's in Atlanta, Georgia. Happy New Year, C.K. Good to see you. This trial, and again, the breaking news this morning is that there's been a delay. There's some sort of medical issue concerning possibly the judge in this case. So for now, what we thought was going to be day 1 of this trial, it has been continued. That said, they are expecting it to be rescheduled later this month, and we'll have our cameras there. In fact, they're already set up. CK, let's talk about the case. The self-defense element, and just at the end of Chanley's piece there, she brought up the defense argument that the prosecution is trying to work in this bail jumping charge on purpose, because once a juror hears, oh, he was out on bail, he wasn't supposed to have a firearm, now his odds of winning the jury over on this self-defense claim, it goes way down, does it not? Your thoughts overall on the case, and specifically the idea that the state has added the bail jumping into the murder charge?
First of all, Happy New Year, Ted. It's great to be here. You know, the bail jumping issue and the fact that he had a firearm when he was not legally supposed to have a firearm is a complicating factor. And if the jury does get that information, does hear that information, and I have to say, Ted, I think it's going to be relevant because it's relevant to his state of mind, to what he may or may not have done. It's not relevant to the actual charges against him, because it's self-defense, but it's relevant to other aspects of his life. Certainly, it's if he committed a crime within the past 10 years, within the past 6 months, it's not too remote. So I think there's a good likelihood that the prosecution will get that in. I do, however, believe that it's not relevant to the case itself, because the case itself doesn't have anything to do with the fact that he was jumping bail or not, but it has to do with the individual. And as we know in these criminal cases, the victim as well as the defendant are on trial. So I think that information is coming in, and I do think that it will be prejudicial. The only reason why it wouldn't come in is because a judge thinks that it's highly prejudicial, and the prejudicial effect outweighs the probative value, and he wouldn't let it go to the jury. But other than that, I think it's coming in. I think it's going to hurt the defense tremendously.
Yeah, and they were adamant that they did not want it to be joined. They wanted to separate the two. But as it stands now, it will be coming in. That was the judge's ruling during one of the pretrial motion hearings. Let's talk about the self-defense aspect of this. This was in Milwaukee. This is right next to Kenosha, where Kyle Rittenhouse is. Edgecomb says that he's going to be using the same witness that Kyle Rittenhouse used, the expert on self-defense. They've contracted for him to come in. You remember him, Mr. Black, from the Rittenhouse trial. And there's this sort of narrative that's being floated by the Edgecomb defense teams that, you know, we're going to see how this justice system works, that this is just like Kyle Rittenhouse's case, but Edgecomb is African-American, and we're kind of testing the system here. Do you buy that, CK, that these are very similar cases, and this is a test of the system, and if he doesn't get what he's looking for, that there's some sort of problem with the system, or are these two separate cases?
I think that these are two separate cases, but there are similarities with the cases. You've got, in both cases, self-defense being used by the defendants. In both cases, you've got videotape evidence, and I haven't seen a lot of the videotape evidence. I've just seen bits and pieces, and enough where I can see where the defense is going with the videotape. Again, what the defense is going to do is try to make it seem as though self-defense was his only option, that he was indeed being pursued by the victim and he didn't have a choice other than to defend himself. I think there's a similarity there, but a difference, a big difference in the case, of course, is the age of the defendant. One of the benefits that Kyle Rittenhouse got, I believe, from the jurors was that he was 17 when it took place. And I think there was an element of sympathy for him. Here you've got a grown man, and I think there won't be sympathy. In addition to that, I do believe the racial factor is going to be heavily discussed and tried in this case, and it will be an interesting commentary if there are different results. So there's similar cases in some respects. There's some differences, as you would expect in any case, but I do think that no matter what, the racial component is going to be tried, because they're going to say, you know, two defendants, self-defense, videos in both. So how is it going to pan out? Is the result going to be different with this assailant being African-American? But I do think we have to take into account the age of Kyle Rittenhouse. And there was a lot of, for better or for worse, we may not have liked it, a lot of sympathy that went to Kyle Rittenhouse because of his age and because, of course, he broke down on the witness stand. And people were seeing this young child, really. That's how the jury must have perceived him, versus here you've got a grown man.
Yeah, you're absolutely right, and that's a great point, that the age of Kyle Rittenhouse absolutely worked in his favor, and the way that he testified, that his age came through. The overwhelming feeling of sitting in that courtroom was like, oh, God, this kid was in over his head. And I think you're right that the jury gave him that edge where it won't take place in this.